my bicycle, dog.
No more guarantors for student loan. Your government cares about your education, and we don't want you to ever have to worry about going to university. The Students' Loan Bureau has a loan for you, so you can focus on your future.
What a flow, what a flow, what a flow, what a flow,
Come on.
what a flow, what a flow, what a flow, what a flow. The water put it just like a freestyle. The lifeblood flowing mile by mile. It's legacy, a beat that don't stop like Bob Marley said. One love on top. The sewage water out of sight, but it's always wrong. Don't lose the light. From factories and wells so deep, crowds, mangoes and fish they weep. Bring water for the garden, keep it green. Save the cash and the earth gets clean. We use the water with a mindful mind. It's out of sight but never far behind. In nature, the answers always flow. Like water running pure, the cycle grows. It renews itself, same drop, same beat. It's all good, man, you got the heat. Water flow, water flow. No clean water, no pipes we grow. Protect our water, protect our future.
Time to go.
Once upon a time in a Caribbean island known for its rich culture, natural beauty, lived a group of people who were buried in piles and piles and more piles of paper. Papers spanning back to the start of time. Then came a bright idea, harnessing technology to work smarter and not harder. The government of Jamaica is improving its operations to serve citizens better. Many services are now available online, and there's more to come. The government of Jamaica building a
No. Members, we want to welcome you and our support teams here for this very important session in the final review of the matrix established, which indicated the extent of the contribution of civil society and a number of other technical groups towards the analysis of the Integrity Commission Act itself and the suggestions with regards to amendments for improving and strengthening the capacity of this great commission to deliver on the promise of the Act itself. We have, since the last time we met, had two pieces of correspondence which we will deal with immediately after the confirmation of the minutes. But I want to indicate, members, that we really want to tidy up our review by tomorrow evening. And so we're going to work pretty hard today and tomorrow all day. And hopefully we can then have the frame of a report which will be presented to the Parliament for then approval and instructions to CPC for the amendments to the Act. The minutes are before you. Do I have a confirmation of the minutes? Member Robinson? Confirm. Seconded by Member Chuck. Member Warmington? Yes. Very well. Matters arising from the minutes. Okay, so I did refer to the presence of two pieces of correspondence that we have. One, in fact, would flow from the minutes of the last meeting, and it had to do with, I think, requests that apparently was said to have been denied by the Jamaica Accountability Meter portal to the Ministry of Finance with regards to a request for update on the public accessibility to procurement database. The Financial Secretary has written to the Clerk of the House in this regard, and I might just read the response for the benefit of the committee. So it's to Ms. Colleen Lowe, Clerk of the Houses of Parliament, Gordon House, 81 Duke Street. And dear Mrs. Lowe, we request for update on public accessibility to the procurement database. Reference is made to a letter dated May 16, 2025, advising of certain developments in a meeting of the Joint Select Committee appointed to review and report on the Integrity Commission's Act 2017. In particular, this ministry understands that the Jamaica Accountability Meter Portal, JAMP, has indicated to the aforementioned committee that the Ministry of Finance and the Public Service had committed to restoring public accessibility to the Integrity Commission's quarterly contract awards, the QCA report. We declare that this ministry did not make any such commitment to JAMP, and no talks between this ministry, the Integrity Commission, or JAMP have been held on this point. In any event, this ministry does not have access to the QCA and is disempowered in respect of its operations. Notwithstanding, the Office of the Public Procurement Policy, OPP, is in accordance with its objective set out in Section 7 of the Public Procurement Act 2015, as amended. The Act has invested in its own database of public procurement statistics, etc. The data are taken from the electronic procurement system, that is the GOJEP, and from monthly procurement report system, the PRS, and submitted by procuring entities. The PRS was revised in 2022 to capture an expanded data set and has been used by the OPPP to inform policy development, training inter alia. It is this data, in fact, it is this database on which discussions were held with JAMP and the Integrity Commission. While not mandated by the Act, this ministry is cognizant of the utility of making the data publicly available. The data and reports generated therefrom are currently under internal review. Upon the completion of this review, it is expected that the publication will be made, together with particular caveats and disclaimers concerning the data set and its accuracy. Yours sincerely, Darlene Morrison, CD, Financial Secretary. Members, that I hope would put an end to the discussions in relation to the allegations that came before us. Okay, any other matter? Any comment any member wants to make in regards to this matter? No? We will then proceed to deal with yes, I'm coming. We'll now deal with, this is a new matter. This is literally new business. The Governor General's office has sent us a note
on the response from the Financial Secretary in the last paragraph. It doesn't have to be a formal correspondence, but I think it would be helpful if we could get a time frame in terms of, she indicated that they're doing an internal review, and then after the review, the publication will be made, etc. If she could indicate, even indicatively, what time frame they're working towards getting the publication done.
Very well. We will instruct the clerk to advise the clerk of the House in this regard when she replies to, yes, okay? Very well. So we have a correspondence from the Office of the Governor General.
I don't know if all the members are cognizant of that particular correspondence. It was sent out, but we never saw it. I made copies. I made my copies, but I don't know if the other members saw. So I believe it would have been appropriate if copies be laid that members can see what we're talking about.
Right, so it wasn't intended to read
Yeah.
the details of the letter, but to reference it for the minutes. And tomorrow, I intend for us to look at it carefully.
No, what I'm saying, if copies can be
members
made for the members who are here,
Yes, I think that a soft copy was sent to every member, to my best knowledge, yes? It was emailed, yes. Yeah. Right, so because it was not my intention to deal with it today, we will have it ready in the other form tomorrow for you. But just to indicate to members that we do have this correspondence, and it will be considered over the course of the next 2 days.
it is important that we get a chance to, that we read through those submissions so we're properly prepared to discuss its contents. And next means I suggest that we just download and read it, because it is interesting for us to look at.
Well, I think, members, that is really the intention of the chair, to give everyone a chance to read it carefully and to be able to relate to it tomorrow as we try to tidy up the report for Parliament. So the agenda item that is now before us relates to the discussions around the matrix, and particularly at the last meeting we had indicated that we would create a table of deferrals and that we would spend today primarily on those matters. Also that the Solicitor General had a very critical role to play in dealing with these deferrals. In fact, most of them that I have before me here are directly in the ballpark of our SG. So can I ask SG that you take note of it and perhaps request our usual committee orator, Member Chuck, to go through. No, please, you do it well. So we start with page 1. We start with page 1, and we look at the Member Chuck. Yes, please. You are usually very cooperative. I don't understand what happened today. Page 1.
So a matter was deferred, which the Solicitor General asked to.
I think, member, what you do is to read it across, to say, for example, the entity that, right, and then you say, you read what the recommendation and observations and queries were, and then we deal with the decision.
All right, so this is a query from Member Wilmington, and the recommendations that an appropriate amendment be made to insert a clause similar to Section 20 of the Contractor General's Act within the Integrity Commission Act. The matter was deferred as the SG asked for further time to examine the recommendation and to see how it would fit within the Integrity Commission's recommendation. Section 22 of the Contractor General's Act, both SG and OPC have agreed to review their files to see if they could find a rationale behind the changes made and the omission of certain provisions from the Integrity Commission Act. So I'll await the SG comment.
Right, so the SG will now give her response.
Thank you. Thank you, Chair. As it relates to this matter, we could not find the reason why. There are actually two sections. It's sections 20 and 22. So I'll just read
sorry,
what,
can you get a little closer to the
I'll just read what section 20 says. After conducting an investigation under this act, a contractor general shall, in writing, inform the principal officer of the public body concerned and the minister having responsibility, therefore, of the result of that investigation and make such recommendations as he considers necessary in respect of the matter which was investigated. And then subsection 2, if any report of a contractor general reflects adversely upon any person, the contractor general shall, so far as practicable, inform that person of the substance of the report. So that's section 20. But it also, as you'll see in the wording of the decision, section 22 was also discussed. And that also was not included in the Integrity Commission Act. So section 22 says, the proceedings of a contractor general shall not be rendered void for want of form. So as it relates to section 20, I know Mr. Warmington, and I think even we saw at the last meeting that the PS board raised some issues, and if this provision is in the Integrity Commission Act, it would resolve those issues. The Integrity Commission wanted section 22 of the Contractor General Act to be put back into to be placed in the Integrity Commission Act, which is that the proceedings shall not be rendered void for want of form. So the first thing is we can't find any rationale for the reason these two sections were not placed in the Integrity Commission Act. It's not that there was no deliberate decision to omit them, but there was no discussion around it either. So that's the first thing. Having considered the comments surrounding section 20 about the procedure after investigation, and also I am aware of practice, I don't know if I want to call it a practice, but I am aware that Integrity Commission, to an extent, they do operate as if section 20 subsection 2 is in their act. As in, I am aware that when there is a report that may adversely affect someone, they do inform persons of the substance of the report. They may not give them the actual report, but they may give them the substance. So I know that they are already operating in a manner which is reminiscent of this. So I would suggest that the committee should consider inserting section 20 of the Contractor General Act into the Integrity Commission Act. So it says it shall so far as practicable. So it's not mandatory. It's as they can do it. But just as it relates to section 22 about the proceedings not being rendered void for want of form, I would not support that provision being included in the Integrity Commission Act.
That phrase?
Yes, because there is, so the Contractor General Act did not have a lot of the kind of process and consequences as you have here, where this is now even way more quasi-criminal. So I don't think the Integrity Commission should be able to just say that for want of form, their proceedings can continue. I don't support that at all.
Chair.
Just to make the point that the the guidance of the SG is critical, as we had, in fact, asked and that we would rely on her guidance for the final decision that we take. So, members, I expect that, yes, there will be a level of discussion around it, but bear in mind, yes.
It's straightforward.
Exactly. So I recognize Member
And then
Guy.
I'll comment.
Thank you, Chair. The SG indicated, Chair, that she's aware that in the current situation with the Integrity Commission, if findings are adverse, that the individual or entity is advised. Is it mandatory that they are? So I think, I'm sorry?
What is this?
No. Okay. No, what I'm saying, Chair, is it mandatory for the Integrity Commission to advise the individual that the adverse finding is made? And if not, Chair, I would recommend that we do approach it as in Section 20 of the Contractor General's Act.
So I was just wanted to clarify, it's not in the Act, no. So what they're doing is just a practice which I think they got from under Section 20. So it's not mandatory. In fact, it's not provided for. But I do think it should be provided for. And that's why I'm suggesting that the committee consider inserting that those provisions into, well, all of Section 20 into this Act.
Chairman, my only comment is that I fully support the recommendation made by Member Warmington and the advice of the Solicitor General. I was going to say, it's not often that I do, but I do know, right, on this particular issue. And as the Solicitor General has said, it should be included in the Integrity Commission Act.
I think members, we really want to move on now. So we have consensus on this, so we can tick this one. So next, part 2, preliminary, yes, Principal Object Act.
Government of Jamaica to make the following urgent recommendations and actions related to the Access to Information Act. Not before, it was deferred. Why was it deferred?
Sorry,
to the SG?
remember to the SG.
Oh.
Because we want to get those off, and then we deal tomorrow with the others.
So the Integrity Commission then had intimated.
Yes. Okay, so the document you have prepared by Mr. Nash, we're just seeing it. So we had shared with him what we thought, what we recorded as matters that we were to review. Mm-hmm. But I'm already seeing one that we didn't have on our list. So, because this came in.
What is this?
You can note it. You see, the first order of business is to deal with the matters that were deferred with the SG.
So some of them, I'm
so
saying I may not be able
so
to
if indeed we can cover
Come back
other,
to this other,
yes,
no problem.
Exactly, then we can proceed.
So
but I was just going to say, as it relates to the
only
JFJ,
matters with you.
Right, no, but I'm also just going to say, this one for the JFJ, I'm saying this is outside the remit of this committee. You are not here to review recommendations or anything in relation to the Access to Information Act. So I think you can actually take a decision.
So why don't we deal with it as resolved? Because it's not before us. So we just put resolved.
My notations committee will be tick and an X. The ones that are not accepted, the ones that are not accepted will have an X, and the ones that are accepted will have a tick. Okay, so that's an X. The next one
is the Integrity Commission recommending that the offenses and penalties of the Corruption Prevention Act be amended in the following manner to include, as it relates to actions of the Commission, not void for want of form. Okay, so we accepted that. So on page 2,
That's a recommendation.
right, 2, as it relates to actions of the commission not void for want of form, we dealt with that too. The private sector organization of Jamaica that proposed that the act be, sorry.
Thank you. Chairman, I just want some clarity. The last row of page 1, can the committee clerk just indicate, is that supposed to be connected to the first row of page 2?
Apparently.
It is?
Yes, yes.
Okay. Because I note even with the JFJ notation, the following urgent recommendations, those recommendations were not repeated here.
Right.
So I don't actually know, I'm not actually sure which recommendations you're referring to there without going back to the full matrix. I just want us to be clear.
Yes, and
If some of these are truncated, can you please indicate at the relevant time? Thank you.
all right. So we now go to the private sector organization. Propose that the act be amended to include a provision which would permit public officials to make an application in writing to the IC to give an opinion or make recommendation as it relates to his rights, obligations under the act or during an investigation. Reference can be made to Section 36 of the Integrity in the Public Life Act of Trinidad. SG? Well,
So I think the decision of the committee was to include Section 20 of the Contractor General Act into the Integrity Commission Act. I think it would address this issue. Because remember, I think the issue from the permanent secretaries was as it relates to an investigation, what happens. And what Section 20, if you insert it, it will say that if there's an adverse finding, as far as practicable, they are to be informed of the substance of the report. So I think it addresses the issue.
The matter in number 3 and page 2 from NIA, I think we've dealt with this over and over. We're not removing Section 53.3, the so-called gag clause. It must remain and made tighter. So it will not be removed. Okay, the gag clause will remain. I think there has been consensus on this. No, right. To hold information until you have a report to be made to Parliament. No, number 6 on page 3, which is the description, functions of the Commission generally, best FM, as it relates to sections 3A and 6G, the objects and functions of the Act include promoting propriety and integrity among public officers, preparing codes of conduct and other advisory material for public bodies, respectively. SG?
Okay, so this is one of the matters that I don't have on my list, but I do recall a discussion about looking at, I think we had looked at some other law. It may have been the one from Trinidad or it may have been from Australia, I can't recall. And I know that there was some discussion about making some adjustments to the functions, but I thought that was more a drafting issue and not an issue. And in any case, I think these matters are already included in the Act. They are in the Act. So I'm not sure why this was deferred, and I don't know why it says what I was to do.
Can I just remind us that we had a kerfuffle with this submission in that the submission was based on some previous version of the Act, and so we should be cautious about.
Number
yeah.
6 and page.
So it's actually in the legislation already. Right, so this one is an X. Okay, next.
Okay. So number 7 is cooperation between other bodies and agreements agreements. It has been recommended that section 7.8 and 53.2 be reviewed in light of the principles of natural justice. The powers afforded the Integrity Commission are too wide-ranging and seem unfettered. It is recommended that the IC Act be amended consistent with the ruling by the UK Privy Council in the Turks and Caicos matter to require that information being sought from third-party institutions be done with the consent of the public official, and to introduce a requirement for disclosure orders issued by a judge in chambers after careful consideration of the evidence supplied by the IC and only in furtherance of an investigation, due notice having been served on the public official that an investigation is being pursued. This is one of the best recommendations.
Yes. SG? Remember, we rely on you, SG, for this. Yes.
Right. Yeah.
Member Robinson.
What happens in a scenario where the public official does not consent for?
Judge in chambers.
Different thing. You go to court. Yeah.
So it refers to.
Yes.
So it then goes to the courts.
Of course,
okay.
of course.
If he refuses to.
If he refuses
if
to
he refuses to cooperate, then
Exactly.
it
Then
goes
he's
to the
dealt
court.
with the
No,
court.
this.
Well, remember the
Well-
provisions of the IC says that, though, already, that
Yes.
they are required to cooperate with you. And if they
Chairman,
No, but what happens now? You're not asked to consent.
don't, yes, that's correct.
So
That's correct.
the provision now being sought is to make it mandatory
Mandatory.
that
That
you
you
are
be asked.
asked to consent
Right.
before the information is sought.
right.
And if you refuse to,
And
then
that's
the
another
IC
matter.
can
Absolutely.
take you to
Can
court.
take action.
So, Chairman, may I just say this is the case from the Turks and Caicos was actually circulated by me amongst members. Because when it came to my attention, it is obvious to me that the IC was acting inappropriately. They were getting information from all the different public bodies, including financial institutions, and they were writing reports using that information. The way that the Turks and Caicos case indicated is that basically that is an invasion of privacy, which is protected by the Constitution in Jamaica. And therefore, what the IC did in writing reports where they got information without the consent of the public official was wrong. And we need to make it very clear in this section that that must be the case, bearing in mind the constitutional right to privacy, constitutional right to privacy. And Member Robinson, if they're doing an investigation and they feel that they need to get information from a public body or a financial institution, all they need to do is to go to a judge and the judge will approve it. Well, they ask you first, and if you say no, get an order from the court. But they can't. And what is more, my understanding, Chairman, is that they're literally threatening institutions that if they don't provide the information, then that the institution could be brought up. And unfortunately, it has gone on for too long, and it's about time it stops. The IC must look at the Turks and Caicos judgment and conduct their business, conduct their investigation in accordance with what was said in that Turks and Caicos case. It was a Privy Council case.
Okay.
I'm in full support of this request from the Permanent Secretary Board. Totally. Fully support of it.
Okay.
Based on the ruling from the Privy Council.
Member Guy?
Chair, Member Chuck made a comment earlier on about threatened institutions. I am trying to recall, wasn't there a case that was before the court, and maybe SG can help us, or one of the legal luminaries across there, or even Chuck himself,
Yes.
where there was a particular financial institution that refused to divulge and it went to court. And the court, I think, ruled that they should order from the court. That. But now the Privy Council, having made this particular decision, I think then it is more justification for it to be included in this here.
Do you recall a
Member
case,
Hamilton.
Chair, this is really just,
Sorry, can we finish? Member Hamilton has the
this
floor.
is really just an observation, Chair, based on
Member Hamilton has the floor.
Member Warmington. I tend to agree with the Permanent Secretary's Board, because if it is that the Integrity Commission has the authority to just request information of persons from third parties, what would be our purpose or the public official's purpose of declaring every year? It really wouldn't make any sense, since they can get the information at will. So I think it would be null and void.
Okay, very well. I see a consensus here that this recommendation will be upheld. Next.
Go ahead.
SG.
Sorry, actually, there are some misstatements. So we don't actually support this because I think it's not been stated accurately. What they say, the case, the Privy Council said, the Privy Council didn't say this. And in fact, they start off by speaking about 78 and 53.2 and breaches of natural justice. We also don't agree. So I don't know if you could just give us an opportunity to just frame it properly, please. No, I'm asking you to just give us an opportunity to frame our argument. So Mr. Foreman will speak on the issues.
Okay, thank you. Okay, so first of all, in relation to the Privy Council decision, there may be a reason why that confusion arose. So at first instance in the case, the Chief Justice of the Turks and Caicos Supreme Court did say that outside of verification during a formal inquiry and with the consent of the person in public life, their Integrity Commission did not have the power to compel certain things. However, at the stage of the Privy Council said that the Integrity Commission's power to issue a summons to a third party to produce documents could be exercised in connection with the formal inquiry that they were conducted. And the decision did not say that information being sought from a third party institution needed the consent of the subject, needed the consent of the person whose information was being sought, if it was done in the context of the formal inquiry that was set out in the legislation. So for example, at paragraph 31 of the judgment, it says it is accepted by Mr. Missick, Queen's Counsel, who was representing the person before the board, that the consent of the person in public life is not required before a summons is issued. And to that extent, he does not oppose the amendment of the declaration made by the Chief Justice to that effect. So at that stage, all concerned accepted that in the context of the formal inquiry procedure under the Turks and Caicos legislation, the consent of the third party is not required. And if we now go to the Integrity Commission Act itself and the specific provisions that were flagged by the PS board, they raise questions regarding the Section 7 and natural justice. Section 7, the marginal note there speaks to cooperation between other bodies and agreement and arrangements. And the section does several different things. It gives the IC power to cooperate with other bodies, duty on other bodies to cooperate with the IC. Importantly, it grants the court power to order a person or body to provide the IC with information and documents which a court deems necessary to assist the IC in carrying out its functions. And this court order can be made on the application of the IC. And there's a requirement that the person or body that is the subject of the court order provide the information or documents that's the subject of the court order. And it has other provisions there. So that's section 7. So that's the section that the PS board flagged as saying is inconsistent. Right. And in particular, subsection 8, which says, notwithstanding any provision in any law, and subject to subsection 11, no obligations as to secrecy or other restriction upon the disclosure of information implemented by law or otherwise shall prevent a person or body from disclosing any information or producing any document to the Commission in accordance with this section. Right? And section 7 itself
the words that I would like to inject into what you're saying, because to my recollection, I don't have my act in front of me, but to my recollection, section 7 speaks to the activities of the Integrity Commission during the course of an investigation. Does it not have that language? Section 7 at all?
Well, Chair, before you answer, my intervention was along the lines of asking if the distinction is when an investigation commences versus the Integrity Commission at any other point. Because the practice now is that it's not when you're under investigation at all. It's at any point. In fact, it has become routine in the way they do their work. So I was really going to ask what Member Golding Campbell asked, which is it when there is an investigation or formal inquiry, or they have the authority at any point in time to request and get the third party?
Before the SG responds, and I apologize, Chair, if we're not following form. Member Robinson interrupted. I now have the copy of the Act. So the language I'm referring to is at section 7.1. The Commission may, in the performance of its functions, work in cooperation with any person or body as it may deem appropriate. Those were the words I was really referring to, because there is a context in which the Integrity Commission can work in cooperation with another body. I just wanted to bring that to the floor in the context of what Mr. Foreman was saying. Thank you.
Oh, there we go. Right, thank you for that. So if I can piggyback, so there are specific powers for the Director of Investigations to carry out an investigation, and a lot of those powers are similar to the powers that a Commission of Inquiry would have in the conduct of their duties, which include certain safeguards for due process and natural justice and so on. That's in a different section. So section 7, as has been pointed out, is right, applies to the Commission itself and it's general. However, the power to compel the production of documents in section 7, it can only be done pursuant to a court order. So the section 8, that says no obligations as to secrecy and so on, that has to be read in the context of the section as a whole. And the context of the section as a whole is that the compelling of a document from a third party can only be done by the court. And outside of the corporation of some other entity. So to the extent that we always sort of treat the court as that buffer between the interests of third parties or citizens, and balancing that public interest in maybe finding out information, we do not think it's inconsistent with what the Privy Council said in the Kiki Varoufakis case.
Sure. If I could, just a quick question, because I just want to ensure I'm following. Is it therefore, you're saying that the IC know the general powers, they're only able to compel production of a document through the courts? Because I get the feeling it's a general section 7, but section 7 is a general section.
In relation to how it, yes.
In relation to the IC generally,
Yes.
not.
So this is part of the problem which I had raised before when I had raised the Privy Council case, because I did not think the issue was with the act. And I said it before, I thought the issue was with the implementation of the act. So I thought that, and this would have been reinforced by what the Privy Council was saying. The Privy Council didn't say that persons must give consent or so. What they're saying is that the Commission must act in accordance with its act, in accordance with the powers it is given in legislation.
Okay.
So that's the first thing. So for instance, a director of information should not be undertaking an investigation.
Okay.
And what we were seeing is that you would get a letter or a request from the director of information
seeking further.
But it appeared to be looking like an investigation.
Right.
And so what we're saying is, because the powers of the director of investigation are wide, as opposed to the director of information. So there are certain, like a summons or these notices that were being issued, we thought it was the wrong person doing it, especially when it seemed to be going into an investigation.
But I'm of the, well, I get the feeling that the director of information also has access to third-party information.
So
because
all
there are
of them
times
can
they will
have
write you
access.
and speak specifically
They
to bank
can.
accounts. How would they get that information if they're not authorized to?
You're correct, but the director of information is only supposed to act in accordance with the act. And the director of information only has the power to ask for information to verify. Let me find the exact term.
So is it that we need to clarify this in the legislation? Because
So
obviously...
this is why I'm saying I think the legislation is already clear.
But they're acting contrary to it.
So that's why I said I think it's a matter of implementation, how they are giving effect. So the Director of Information and Complaints shall, 32(1)b, make such inquiries as he considers necessary in order to certify or determine the accuracy of a statutory declaration. So the Director of Information and Complaints, in order to undertake that power under 31B, to undertake the duty under 31B, can use Section 7, and he could ask an entity to cooperate with the Integrity Commission. That entity may say no. So the Integrity Commission then has been given the authority and the power to go to the court. Now, when making the application to the court, you have to now have affidavits, you have to have some substance, some evidence. It can't be a fishing expedition. You'll be going to the court to say, I, the Director of Information and Complaints, acting under 32(1)b, I need to determine the accuracy of something in a statutory declaration, or I need to certify something. And in order to do that, I need this information. But that's the remit of the power of the Director of Information and Complaints in terms of, to me, requesting the information. I think anything beyond that would now fall under the remit of the Director of Investigations, because it clearly, if you're going beyond that, it must be an investigation. And so what the Privy Council was saying is the matter that went before them, this whole thing of persons of the commission, the Integrity Commission of Turks and Caicos, going to all these banks and so, in that situation may not have been appropriate because it may not have been done properly in accordance with the powers given under the Act.
And would you say, SG, based even on everything you've said, that before the IC asks a third party for information, they should request that information from the member?
No, that's not what you're saying.
No, but it seemed to me, if they're going to ask for information from a financial institution, the financial institution firstly have a right to say no, but the financial institution can say yes. But if it says yes, isn't that an invasion of the member's privacy?
think even if it is considered an infringement, I suspect it would fall under the general derogation. I think it would be something that would be considered reasonably justified in a free and democratic society because of the aim of the act and because of the fact that when you look at the objective of the act and you look at whether there is any other way to get it. Remember, especially if it's information and complaints, they'll be just checking accuracy and trying to verify what you sent. So they can't come back to you to verify information you sent to them. To be able to verify, they may have to go elsewhere. But this is the reason Member Guy spoke about a decision from a matter that involved a bank. So clearly that bank did not give the information, and so what the Integrity Commission did was went to the court. And they were able to justify before the court the fact that they needed to get the information. So what was handed down, I think, was an order. I don't think there was a decision, but the order was compelling the bank to produce the information.
And which takes me to the question I wanted to chair. SG, is this decision peculiar to a particular circumstance, or is that over a carte blanche decision of the court? Isn't it a case-by-case thing that needs to go to the court each time? Or is it a general order?
So I haven't seen that order. I only saw a report in the news. But from my understanding of the law, it would have to be very specific. I can't imagine that they would have gone with a very general and vague order. But as I said, I never saw it, so I can't speak to what was done then. But as it relates to how I know the courts operate, it would have had to be very specific.
Is there any way that the SG or her team could get a copy of that order to have a look at it and to advise the committee appropriately?
Yeah, we can try.
Because of the timelines that we're working with, that trial SG would have to be very active. So, we can look at tomorrow when we meet again, because I think it's critical for us to clear these deferred matters. And this one seemed to have the full attention of the committee. Yes? So
when I said try, I would have to get the name of the parties and then we would have to go to the court's registry and try and get a copy, because orders are usually public documents. I say usually because under some laws they aren't, but I don't see any restriction here, so it should be a public document. But it means I would have to be sending a staff member to try and get a copy of it from the registry of the court. So not all of that is under my control. So I can endeavor.
okay, so we will hold this one for a decision. Mr. Simmons, you wanted to say something?
I'm not familiar with the matter. Let me just say that clear. But I'm saying if it's a matter that involves the IC, maybe the IC has it, and the committee could see if the IC would want to disclose it. The order, that is.
Well, I think the SG has given an undertaking to look at it. We will offer her the opportunity so to do, and we will defer this one for the next 24 hours, and hopefully we will be able to make a determination on it when we meet again tomorrow. So can we move on to item 8?
With going to item 8, I think you said we're only referring to matters that the SG has to comment on first, because item 8 is the committee. There are lots of matters deferred that the committee needs to look at. So
We said the priority would be the SGs, but
Right,
if there
so-
are
so
matters
if-
that we can dispense with quickly here,
Well, it
by
seems-
all means.
It seemed to me that the next matter that we have asked the SG to look at is number 30. Based on the matrix that was provided today. So, SG, number 30, we had the establishment of division and appointment of directors, a provision from the PSOJ, which said for section 30:10, it is suggested that a maximum term for reappointment should be included, e.g. no more than 3 to 5 year terms. We said there was a decision pending, was agreed, but pending research to be done by the SG, that the executive director and other directors should be appointed for a period of 5 years and shall be eligible for reappointment for a maximum of an additional 3 years. SG? I could, if
So it varies from law to law. So I was asked to look, so I don't have the listing of the different laws, but each law, there's no standard. And I think it's usually a policy decision, and it's usually based on, you look at factors like availability of persons, and in fact, that factors in, especially when you're looking at giving them the power, putting in the power for reappointments, because you have to look at the available pool of candidates, let's call them that, persons available and willing. And then you look at things like whether you want a quicker turnover or not. And again, that would depend on policy. So for instance, depending on the subject matter, it may be that you want persons there a little longer because you want some more stability in how matters are treated. It could be though that you want, when you have a shorter term, it means you want more turnover of staff. But then again, if you're putting reappointment periods, it would suggest that you're still looking at some amount of stability in terms of having persons there longer. And it could be that they get more familiar with the subject matter, they become experts in that area, and can handle matters in a different way. But as I said, it really just varies from law to law, and it really is a policy-driven matter.
So sorry, essentially what happened here is that the committee had agreed in principle with the recommendation for 5 years with the provision for an additional 3, which is what it is now. So if there's an agreement there and it was subject no to your guidance, and your guidance seemed to concur, yes, that it is a policy decision, then this one will stay. So we agree to that. Okay.
There's another matter.
I think, okay, so the act says the director, so for instance, the director of, this is the ED, a director shall hold office for a period of 5 years and may be eligible for reappointment. I think the comment was made about capping the reappointment, meaning you couldn't do it more than twice or 3 times.
Yeah.
But that is purely policy driven.
Yes, of course. But I think what is said here is reasonable in that you have a 5-year term with a provision to get another 3 if possible. But certainly, yes. I think that's reasonable. It's not capped. No, it's not capped. We understand that.
So,
Chair.
Let me hear from you.
With capped? Like what is suggested?
No, what is recorded here is that the recommendation would that it be 5 years with a provision for 3 more. And that's the recommendation. And I think that's what we're accepting.
That's what is accepted.
Yes.
Okay,
But
so,
Chair,
Yes.
Chair.
so they,
Why are we not capping it for another term?
what do you mean?
About another 5 years? No, I'm asking. We made a decision.
No. in all fairness, we went through that extensively, and then we said that the SG should come back to us to say whether, that which we agreed on would have been accepted overall. And she has come back and indicated that it's a policy matter, so therefore we're proceeding as we agreed. Team, I don't think we want to get to rehash every aspect exactly of our discussions. It's 2 years we've been talking about this.
No, I acknowledge that we had agreed on a 5-year plus a further period of 3 years. My concern now, though, Chairman, what happens if the person is in a, say, in one position as a director and applies to move to, say, the executive director, for example? You understand? Do we cap it still at the 3 years?
No, but it would be in a different skill set, different occupational arrangement, different everything. You can't do that. A person who is in a particular job situation, he then leaves to another, whether it is by,
moving across.
Exactly, whether lateral or...
So that would be the first 5 years?
Yeah, but that wouldn't be the first 5 years. The person would be in a different position. So his new 5-year begins when he takes that new position.
So a person could remain there up to 13 years. First 5 years, move across a 5 years.
Well, I mean, if your efficiency and your performance level merits a consideration for you to move into a different position, fine. But that is something that the directors and, of course, the commissioners would have to decide. Yes.
All right. The next one is from the Permanent Secretaries Board that recommended for Section 39. I'm still at 30 on the next page, page 10. That at Section 39, it is recommended that in instances where a director is terminated due to misbehavior, due process is followed, and a tribunal established to facilitate a fair hearing. At Section 3010, it is recommended that a specific period for reappointment be stated, which we have already said so far. SG, you were to just clarify. Isn't that the same thing you had just done? Based on what the matrix is saying, it seems to be the same thing. Go ahead, SG.
So this was not on my list. But just looking at it...
It's a repetition, a corollary.
No. The second part about the reappointment, but I'm looking at 30 subsection 9 about due process being followed and a tribunal being established. So I think maybe the issue is that there is a tribunal as it relates to the commissioners maybe, but none for the executive director. But even though there is no tribunal, even though the Act does not require the appointment of a tribunal, due process has to be followed. We have to follow it. That's our law. And we have a plethora of cases to remind us in the event we forget. And the normal course of things is for a tribunal to be appointed, whether or not the Act actually says it. So the Act doesn't need to say it for it to happen.
All right. No, Chairman, I mean, the next intervention that we're asking the SG is number 42 on page 12. The examination of statutory declaration and publication of summary declaration in certain cases. A request from the Integrity Commission that Section 42(1) and 3. It is proposed that due consideration should be given to defining or clarifying the words examine, duly completed, uncompliant. The reference clarification would remove any ambiguity on the part of the Commission and or its stakeholders regarding the declarations as being completed. This was deferred for the SG to make certain, you're aware of it, SG? Because in that provision in the matrix, SG, The chairman asked Mrs. Aldred, the SG, to research a matter further in order to provide the committee with guidance. SG indicated that the matter would be for the Legal Reform Department to conduct research on. And Member Ford said that the Ministry of Legal and Constitutional Affairs will assist the agency. No final decision was taken at that time.
You can. I vaguely remember this discussion, but I don't recall any definitive decision being taken on it. But what I can say is that I don't think the issue involves the Turks and Caicos case. I think it's more a matter of interpretation. I don't think this is something that can be resolved simply. I think it's really a matter, my personal view, of rationalizing the terms being used in the Act. Because I don't think, and maybe, I'm not aware of the Integrity Commission ever, it's clear that they do examination, but I don't believe they ever say to anybody any declarant that they are compliant or duly completed. I don't believe they've ever used those terms. And I think, based on recent experience, I think what they've been trying to do of late really is to certify. But how they go about certifying, I am not too sure. I really truly think the Act needs to be reviewed to see if the terms can be rationalized, to see what these things really mean.
I believe that is what we had asked, you see. We were all very concerned because terms like...
Right. I'm clear on the word examine,
duly
which is what
completed and what is meant by duly completed.
Yeah, but
and being compliant, what was meant by being compliant. In other words, what we needed was a definition so that the declarant could be satisfied, yes, that I am compliant based on 1, 2, 3, 4, 5 things.
I don't think we can answer that question. I think my approach would be to ask the Integrity Commission how they intend to comply with that, because we have actually given them wide powers into how they carry out their responsibilities. So they really should need to indicate what it is that they do, and then we can probably decide if we agree with how they operate. Maybe what we could consider really is putting in rules for or regulations for the Integrity Commission to comply with. That would be my best answer, rather than leaving it wide and open for them to decide when someone's declaration is duly completed, which to me would suggest if you complete your declaration, as far as you're concerned, you have completed it. Whether or not you're compliant or certified is a different matter. But if it's completed and you have followed it to the T, you have complied with the declaration, but then certification is another matter.
Right.
So I don't even know that is even in the purview of the IC to decide whether you're complete or not, unless something should come up from some other source that you didn't declare something. I don't know. But I'm not sure if, from where I sit, I'm not even sure if the Act needs all of these words, which is why I say I think the words need to be rationalized.
Yeah. So the fact here is, can the Act so define these areas? And is it that we're asking too much? SG? Yes, what we're saying is that can the Act, in fact, define what is compliant and what would constitute certification? Or are we asking too much? And isn't this perhaps... Yes.
I hope I'm not repeating what my colleagues have said on the issue, but the Act requires declarants to make declarations. Failure to make the declaration, making a false declaration, making a declaration that is incomplete, which would also be a false declaration, triggers an offense. It triggers a provision that creates an offense in law. And so the remedy, when the Integrity Commission does its investigation, reviews a declaration, does its investigation, the remedy is to pursue the offense, pursue ensuring that the person is prosecuted under the particular offense. I have long not understood why the provision for the requirement of certification came, because if you have not done what you're supposed to do, then you fall afoul of the provisions and the IC has an action to take. If you have submitted an appropriate and a proper declaration, then there is nothing further that either the IC or yourself should be doing. There is also a process within the Act where the Integrity Commission may request further information or further clarification. And there is a process in which you can respond to that. So I think I have said it in a previous meeting. I don't understand certification, and I don't understand it in the context where if the Integrity Commission does not certify you and there is no offense with which you are being charged, what then is the position for the declarant, and where do you lie in that regard? And it's nowhere. You lie nowhere. And that, Mr. Chairman, has been the gravamen of my concern with the destruction of the reputation of public servants. May it please you.
Well, I see also in the decision column of the matrix that we had a request, I think, from the SG for support from the Legal Reform Department, and that the Minister Malahou Fort did indicate that they would assist the AG's department in this regard. So
as I had indicated at that time, this is not a matter for the Attorney General's chambers. This is a drafting issue and something perhaps maybe for legal reform, but this is not something the Attorney General's chambers can assist with. Because if it comes on to statutory interpretation, we have rules about that. If the words that are used are not defined, you look to see if they're a term of art. If it's not a term of art, you're going to use the ordinary meaning, use a dictionary. And this is what you would do here. So we don't see, outside of that, using the rules of construction, that's as far as we could take it from our remit. So I think what the committee is asking really falls within both the drafter and Legal Reform Department.
Okay, Member Charles.
Thank you, Chairman. Just for clarity. All right. Upon reading, and not to extend it too much, but just to understand, we're speaking of section 42(1) and 3. Correct, AG? Which, well, maybe I should say to the legal reform, which 42(1) says, the Director of Information and Complaints shall examine or cause to be examined every statutory declaration that is submitted in order to ensure that it complies with the requirements of this Act. All right, so that's where the words examine and comply are used, or derivatives of those words. 42(3) goes on to speak about the statutory declaration having been duly completed. Fine. And those are the three words or phrases that are utilized in the recommendation here. Now, it asks in the decision, or makes reference to the Turks and Caicos matter, which I am assuming is the Kiki Varakis. Is it? The Kiki Varakis Privy Council case. And I would imagine then that what the AG was saying, which is very, very clear, is that she would want the Legal Reform Department to conduct the research into that case or whatever other relevant case to guide, or what else I'm saying, whether it is to the case or whatever other relevant things, to see whether or not there is anything that can assist in removing the ambiguity as it relates to the commission and stakeholders regarding declarations being complete. So the question is, has that been done?
Right. That's really what and she's saying. And
So
I'm
we're
not
saying
sure.
that that has not been done, so we move on until it is done. You understand what I'm saying, AG?
Yes.
So the question is really, has that been, if it has not been done,
that's my
we can't
point.
answer the question today, we move on, answer it
Yeah,
another time.
That's my point, that I wanted to just hear now from Ms. Brown. And,
But we can't answer if we don't know what the issue is, Chair. So even if you want us at the OPC to define these terms, we have to know what the mischief is, what is the issue that you're having.
So the issue,
Yeah,
if
because to
if I
my
can
mind,
assist,
my mind, when you look at how the words are used here, they are to be given their ordinary meaning.
then that is,
Right?
then
So,
that would,
so my point is, if there's an issue, the commission then needs to say to us, these are the concerns that we have, why we are asking you to define them and give us what parameters you want us to define them. You just can't ask us to define them like that.
yeah. Okay, I think that we've had a long run on this one, if you recall, when we had the discussion. In fact, from the original matrix, there's quite a bit here on it. And
can I just provide some guidance?
yes, please.
Or at least try to assist. In my reading of the recommendations, Ms. Brown, it speaks really to a question on one particular issue, reference of completion. And it appears that whatever the discussion was, there was some ambiguity or concern as to clarity being needed as to exactly what completion is. If you refer to the actual act, it would be what is duly completed.
Right.
Yes? Or what does it mean to be duly completed? It appears that what is being asked is for the Legal Reform Department to give an opinion if the case in Turks and Caicos or any other relevant document or information can provide further guidance on exactly what it is that we're referring to when we say duly completed. That's how I read it. I don't know, AG, if you could see, you agree? Yes. That's how I read it. I hope that helped. No, you were saying that you wanted to know what. I think that's what has been asked. It's not the examine or the word particularly comply. I think it's really...
think what we don't understand is what's the ambiguity. What duly completed means you complete the form and it's signed.
Understood. Literal
so
fine.
I think, right, literal meaning. So I think that is why we are all having a constant issue.
Let me tell you where I agree completely with you that there's no real great issue, but in the decision it refers to this case. So it appears to me that there must be something coming out of the discussion that the Privy Council had that provides further guidance. If it is not so, then say it is not so.
So yes, I see that
it
on
even
the
says
sheet.
the case
It refers to the case, but I think when you go through those minutes, you'll see that there was a lot of discussion about a number of matters. The case doesn't really address this. And you'll see that I was asked to circulate the case.
Can I read it? I like to read it out so people can understand.
Yes,
Listen.
and I was asked to circulate the case, but it was not in relation to this point.
Let me read it. This is the decision relative to that recommendation. Solicitor General, Member Chuck suggested that the committee defer the section and requested that Mrs. Aldred circulate the case from the Turks and Caicos to the members of the committee. He, which is Chuck, implored that members read the case, which could provide a better perspective of the proposal the committee could put forward in relation to the section. So it appears, I'm not saying you know, it appears that the member considered that in that case there is some guidance in terms of what duly completed is. So if you're saying there's none, then the answer would be that there's none.
No, I'm saying if you look at the minutes, I don't think that part of the discussion, this is not a decision being lifted as a decision in the minutes. I think this is compiled, having read minutes.
So you're saying it doesn't refer to this?
It was, the discussion about the case was not in relation to this very specific point.
Well,
it was
then.
generally, because we were having a discussion about Section 42 and a number of things, including when the parties must consent, and you see, this is dealing with the Director of Information and Complaints, and I was raising the issue, of course, that I think persons may not be acting in the manner they are supposed to act under the Act. And then, of course, there would have been reference to that case, because that's what the case really deals with, not to say that it would have addressed the issue of the clarifying the words examine, duly compliant, duly completed, compliant, and so.
So what does it refer to if it's not referring to 42?
The case?
No, this decision.
That's what I'm saying. So you would have to ask the committee clerk, because he prepared this, and I'm just seeing this for the first time.
Okay.
But I'm saying I know he compiled it just reading through the minutes, and what he would have done was pull together things from the minutes to create this matrix.
So maybe we need to look on the minutes, but not to extend it further.
I share that view, because I think
it's problematic if it is that we have a decision that is connected on our matrix to a recommendation that it ought not to be. How many others are?
No, but where we have a lack of consensus on the matter, the status quo remains.
But this is not lack of consensus. What is being said is that it is highly likely, based on what AG considers, that this recommendation, this decision, really ought not to be placed here on the matrix, because it doesn't appear to be connected to the observation that we are discussing, which means me who would be reading it, I'd be reading what would be misinformation.
Well,
my assessment would be,
no, but
would be flawed, because I'd be assessing.
The outcome is the same, whether there's consensus or not. The outcome seems to be the same.
Is that a matter of consensus?
But I agree with you
yes.
that yes. But I'm saying the outcome would be the same, that the status quo would remain. Because there wouldn't be any basis for you to be amending, because you're not sure what the amendment should be.
No, but then what would happen, respectfully, Chair, is that the clerk, if that's the right title for Mr. Nash, or the council, ought to look on the original notes and provide some guidance if this is actually disconnected, or if what we have before us is correct.
So this is boy, it's hard to read.
Mr. Chair, it could be that there was a discussion, as Mrs. Auditor suggested, around the case at the same time that the point was made. But it doesn't mean it was necessarily connected. So the minutes may, in fact, be reflected correctly here, but it doesn't mean that a mistake was made in making the connection between the Turks and Caicos and the point being made. But more critically, I think we need to be aware of where the concern is actually coming from, which is from the Integrity Commission itself. The Integrity Commission is the one that has raised an issue with the definition of these words. So I said earlier, and I recommend, I think it's probably best to get from the Integrity Commission what their practice is when they examine, duly complete, comply, certify, verify, whatever words are in the Act, and then see the issue that they have, and then see how it is we can then amend, if necessary, the statute to clear up any ambiguity, because it's clear that they have a problem in defining these words.
Reasonable suggestion, Mr. Simmons, and perhaps the committee might want to accept and follow that course, but we would have to ask them to come tomorrow because we really want to complete these matters. Yeah. And I don't think it would be a hard ask because it is their recommendation. So, yeah, very well. That's the decision. Next.
Two, page 13. I think where it involves the SGs, the recommendation of the Norman Mandel Law School that proposed that Section 42(3)B required the publication of the summary of statutory declaration for ministers of government. For Section 42, timelines also needs to be included for the examination of the statutory declaration as well as requests for additional information. It is recommended that a time limit of 2 years be set for the examination of the statutory declaration at Section 42(1) and for requesting additional information at Section 42(2). Further, we propose that where the additional information is requested, the Act explicitly specifies that such information shall be limited to the period within which a public official has held his/her office, and in cases where the public official is being investigated for breaches of the Act or allegations of corruption. The Permanent Secretary's Board also opined there is need to strictly enforce a provision of Section 42(3)A that states that where, upon examination of a statutory declaration, the Director of Complaints is satisfied that the statutory declaration has been duly completed, he shall cause to be issued to the public official or parliamentarian, as the case may be, confirmation thereof in writing, referred to in some jurisdiction as the compliance certificate. See, for example, Section 13(3) of the Integrity in Public Life Act of Trinidad and Tobago, which states, quote, where upon an examination under subsection 1, the Commission is satisfied that a declaration has been fully made, it shall forward to the person in public life a certificate of compliance. So basically, the SG, it had been deferred so that the SG could give us some guidance or clarification on this. I see Ms. Petrina would like to come in. Yeah.
It's the same discussion that we just had. Anyway,
I wanted to caution the committee chair that, for instance, in the case of Trinidad, where you have that certificate, is not every single public official is required to file a declaration. There's a schedule of public officials. Same like in Grenada. It's not every public officer. Because think of having to certify every single public official in this manner if you were thinking of...
Yes, that's what it
No,
said.
sorry?
That's what they were saying here.
No, but
Ministers of
42(3) doesn't only speak to the minister. It says the public official or parliamentarian.
Mm-hmm.
So you get confirmation in writing, and then, so if you're going to issue this certificate as is being proposed as in Trinidad, I'm looking for the schedule for Trinidad. Trinidad, yeah, they only, right. So if you look at the schedule for the persons in public life, they're specific to government ministers, persons, members of the House of Reps, permanent secretaries, members of local government, judges, magistrates, senators, members of boards, and, as I said, permanent secretaries and chief technical officers. So they're specific. It's not every single public officer is required to file with the Commission.
Yes.
I'm on page 13 of 16, the Norman Mandel Law School recommendation. It is seeking to expand from the Prime Minister and the opposition leader. Yeah, well, not sure I would support that.
And that's not supported. Yes. Well, when we will be going through, after the SG, we'll then be going through all the others, which are easy, I believe, for us to deal with. The ones that we really had difficulty with, we've asked the SG to opine on. And the others, we expect that, the committee will move reasonably expeditiously to deal with.
What is not clear, is that what we're, especially the permanent secretary board that is asking to see for statutory compliance, that, you know, I know that having received many of these complaints, they mean nothing because it actually says it's not an audit. So I'm not too sure, you know, that it makes sense anyway. You know, in other words, if it is not, if the certificate of compliance that you get for a year doesn't mean that you won't go back. I'm not too sure what's the benefit of having it.
Yeah, it's an interesting.
I'm on page 14 of 16, and I just want to be clear about what the Permanent Secretaries Board is asking. This is the second paragraph. Are they saying that if the Integrity Commission is requesting additional information from a declarant, that information can only be limited to the period in which the person served in the current capacity, and if not, can only be triggered if the declarant is being investigated? Let me explain why. I think some of us have gotten requests for information which would predate our involvement in public life, on companies, accounts, etc. So I just want to find out. Now, there may be a legitimate reason to request it if you believe that that information can help you solve a problem.
Yes.
But what I'm getting from what the Permanent Secretaries Board is saying is that unless you indicate that the person is under investigation for something, then you should limit to the period in which the person has served in public life, and not go back 30 years just to try to find out something. And if that's the case, then you need to tell the declarant that you are being investigated for so-and-so. I mean, I can say openly, I mean, a company I was involved with 30-odd years ago, I got a request about it. To be frank, I didn't even remember the company existed, right? So, you know, I do think if that is what is being asked, I'm supportive of that. Because now you may have a declarant now who may have served in a different capacity within the public service in the past. Now, if that is the case, that's very different from someone who had no involvement with the public service and is being asked for information which predates their involvement in public life.
Good. Okay, so SG.
So, all right, so the first thing is the PS board was asking for a time limit of 2 years. And that's really fettering the powers of the commission, but that in the end is a policy decision that would have to be taken, or the committee will have to take a decision whether you want to limit an investigation. And it's not an investigation. So that's the first thing. Section 42 is not dealing with investigations. It's the Director of Information and Complaints that's operating under Section 42. So I understand that persons used to be concerned because they were getting notices from the Director of Information and Complaints and on what appeared to be an investigation. And this is why I said I think that is improper. It was improper. It should have been coming, if it's an investigation, that notice or summons should come from the Director of Investigation. So I think it's not an issue about, it's not a flaw with the Act. It's about how the Act was being utilized and implemented. So the discussion about an investigation is not proper for Section 42 because the Director of Information and Complaints is not to undertake that kind of investigation. So to me, the big issue then would be whether you want to limit the time within which the Director of Information and Complaints can examine a statutory declaration. That's for the committee to decide whether you want to put in a time limit.
Very well. Our members? I think the SG has been very clear on that one. Are we going with the permanent secretary's recommendation of a timeline of 2 years, or are we going with what is the accepted? Yes?
Just to explain, so, and I can speak from experience, I will get requests asking me for more information on statutory declaration that would have been submitted like 5 years ago. And a number of members of my office, for instance, had to go through that, trying to get information 5, 6 years before. And I think that is the issue that the Permanent Secretaries Board is trying to address, and saying there should be a time limit.
Yes, we understand.
But you have to be, the committee
No,
understood. Okay.
I think we understand that. I mean, but I think what I'm reading is that members think that perhaps to go to 10 years, 7 years, and more so to go during a period when you're not involved in public life, then it is a little stretch. That's the sense I'm getting from members. But I don't know if 2 years is a period. If members are saying 2 years, we could, the chair is always at your command in that regard.
This is the reason why I asked for that we delete section 63. Yes. 63, where they got the authority to go back asking for information years prior. 7 years or what have you? But I'm saying the Integrity Commission Act is more than 7 years old. So why would you need to go back another 7 years down the road? So I'm saying there's no need for that. So we ask to delete section 63.
All right, so can we have some guidance from the committee in terms of the timeline that is being recommended? Member Hamilton?
Chair, I'm just trying to figure out what is reasonable, or probably what is typical, as indicated by Member Golding. I'm in agreement that the Director of Information shouldn't be asking for information after 7 years or 5 years that you would have submitted a declaration. I think that's a bit unreasonable. If it is that an investigation is being done, then it should go to the investigations director and not stay in information. It's whether or not 2 years is reasonable. For me, it's 2 or 3 years. I don't have a difficulty with that period.
Okay. Member Chuck.
Yeah, I think the more important point is what Member Robbins has indicated, and also the SG. I don't have a problem, they go back a little, but when you go beyond the time that the person is in public life and ask questions about, did you buy a car in 1991, when you have only been in public life for the last 10 years, I think, and admittedly I know of one case, and apparently it is a whole wreck that the member did not actually turn in the certificate of ownership. So it is still in his name, but it has not driven for decades. But they ask about this vehicle, only to be told that the vehicle is a wreck. Again, Member Chairman, I was asked about 2 companies that at beginning I said I don't know about these 2 companies. Save and except that my secretary had formed 2 companies that law firms usually do in the late 80s or early 90s. And I had to go and check. I asked them where you get these 2 companies from, and they sent me documents from the company's office. And I had to go and spend money to close them when they were already in the archives of the company's office. And this was long before I went into politics. So I agree with Member Robinson that, persons may come into politics, they might be elected as members of parliament, and within a year or 2, they're being asked for matters that they engage in, decades before. So I would say, Chairman, that somehow we need to limit it unless they're doing an investigation. If they're doing an investigation, I understand.
5, 7 years.
And I would say a period of, say, 5 years back, but, you know, if they're doing an investigation, I guess it's open secret. It's an open, you know, scenario. But just to ask for information, just like that, I don't know if it is appropriate.
But,
Yes.
Chair.
Okay, we have to wrap up on this.
I agree,
yes,
but Member Chuck just brought in another issue. So the issue of investigation is separate from the information component. So we have to ensure that there is some clarity there as to what it is we're discussing now. Information in 42.
Well, it's 42, which is
right,
information.
but he mentioned the investigation part of it,
Well,
which is separate.
no, I think we're focusing on 42.
42,
Yes.
okay. Information only,
Yes,
okay.
indeed. Oh, yes.
Just a question, Chairman. I wonder if perhaps, I think it might reside with legal reform. If they could just advise us if there are similar provisions in other acts, in other jurisdictions, and what pertains there in relation to the timeline. Is there a limitation on the period for the information and complaints portion, the examination of a declaration portion of the process? If they could, if they don't have it today, that's fine, but if they could come back to us with that, I'd appreciate it.
Very well. So we are saying that there is, in fact, a positive look at 42, but for a timeline to be determined. And we're asking the legal reform to research jurisdictions where best practices are possible to be drawn on to assist us in a timeline that is reasonable and fair. Okay. Yes.
The final matter for the Solicitor General, I think we have dealt with it.
But we
At
need
page
her to
15
stay
at-
with us because we have the other
Before you proceed,
deferred items.
Member Chuck.
No.
Yes?
I'm saying it's the final on Mr. Nash's list. It's not the final that we have.
That we have, quite so.
Right. So there are a few other matters that we identified
Yes.
that we were to consider. So
Okay.
it's not on your list, but I
Yes.
have some other.
Please consider
But
them
but
because
we
have
needed to
clear that
know
up
though
today.
if there was a decision as it relates to the bottom of page 13 to expand section 42 3B.
Page 13?
13, right at the bottom, Norman
Yes.
Mandela Law School, to expand section 42 3B. Is it accepted or not?
No,
No.
It's not accepted.
we
Oh.
not
No.
accepted.
Was not accepted. That one definitely not.
Minister Charles wanted to say something.
So, and then, okay.
I'm sorry, Minister Charles?
So in relation to the request for legal reform, I was just saying it's two different matters. So I imagine they will be looking, one, on the potential limitation in terms of years, whether 2 years is reasonable in comparison, and two, within that period, it is also posited that any additional information requested should be explicit to the period within which the public official held office, and also be connected to an investigation for breaches of the Act or allegations of corruption. Those are two separate things that we'd want some guidance on.
Okay. Mr. Brown, you took note of that, yes? Or Mr. Simmons, you already you took note of what Member Charles indicated a while ago. Member Charles, can you repeat for the benefit of Mr. Simmons? He needs to take some notes to guide us for tomorrow.
I was just saying, for the notes, for the record, reference was made that legal reform would be researching the standard in terms of the limitation of years in comparison to other jurisdictions. And I was just highlighting that in addition to that, the recommendation also raises another important issue that is placed before us, which is whether within those years, whether it is 2 or 3 or 1, within those years, any additional information that is requested ought to be requested explicitly relating to a period within which the public official would have held office, meaning you can't go back to 30 years ago, and that it also should be connected to an investigation for breaches of the Act or allegations of corruption. So that is something that the committee would want some guidance on, in addition to the limitation of years.
G, would you take the 2 other areas that you have?
Right, because in relation
so we can
to
finish with you in that sense,
because
and then go to deal with the other deferrals.
Right, because
yes.
and even the final matter, we said we would only deal with it after we have dealt with the deferred matters.
Yes, yes.
Right. So we wait on SG and then
Yeah,
we go
and then
back.
we go back to
So,
page 1.
yes, no, so, no, us. So we have our own list of
Yes, I
some
know.
matters.
So
Okay.
just tell
So,
us which.
these are all coming from recommendations from the Integrity Commission.
Yes.
So they made some recommendations, and we were asked to look at them and give you some input. You want to start?
Right, so some of these we identified from the June 1, 2023 meeting of the committee. One recommendation, the development of sentencing guidelines for all corruption and bribery offenses commensurate with the gravity of the offense. The development of sentencing guidelines is the remit of the sentencing committee, the judiciary. There's a committee that does that, so that would not be for the committee to deal with. B, the imposition of term bans from office and forfeiture of pensions in the case of public officers who are found guilty of an act of corruption or breach of fiduciary duties, prescribed good governance and integrity legislation and standards. The broad response from us is that that recommendation in some ways a bit too opaque for us to endorse it. In relation to term bans, for example, those matters can be dealt with in ordinary legislation. Certainly in relation to those public officials and parliamentarians whose offices are regulated by the Constitution, and the Constitution sets up bases, for example, for parliamentarians to be removed from office, for judges to be removed from office, etc. So that could not be done through ordinary means. And as well, other legislation which either establishes statutory bodies or governs the public service generally have particular rules that govern those types of things. And we would say that any amendments there would need necessarily to be considered sort of on a sort of case-by-case basis. In relation to pension?
In relation to forfeiture of pensions, it's also not something we can support. So pensions are regulated by law, and you will see that starting with the Constitution, and then you have ordinary law that deal with how pension is allocated, given, and how it can be withheld. And usually it's very circumscribed in how pension can be withheld, and this does not fall under those provisions where pension is withheld. So normally it is for repayment of debt due to the government, and almost all of the laws have this, to the Jamaica Civil Service Mutual Thrift Society Limited, or the payment of court-ordered maintenance. Those are the situations generally in which pension can be withheld. And this is applicable for public servants, for the judiciary, who have their separate laws, And even in the Retiring Legislative Allowance Act, the act that applies to parliamentarians, and also the acts that apply even to councillors and mayors also. The provisions are usually pretty standard. It would not apply in this situation. It was just their recommendation.
Right. I think the basis was that as part of penalties, as part of sanctions. But of course, one difficulty with the recommendation is that in instances where somebody is convicted, for example, of defrauding the treasurer or something of the sort, the Corruption Prevention Act or the relevant laws, certainly the Corruption Prevention Act, it allows the court to impose a fine and or a term of imprisonment. But the provision for a fine is not limited. All right? So the Supreme Court will have full discretion to determine what the proportionate fine is, having regard to the circumstances of the case. So presumably, it would be the court would be in a position to ensure that the wrongdoing is matched by an appropriate sanction. So there may be an argument that taking somebody's entire pension away might be wholly disproportionate to the particular crime that they've committed, which was one concern that we had. And the Corruption Prevention Act also has provisions in there for forfeiture of property from the convicted, from the proceeds of whatever was taken away. So it's not, it's not clear to us that further amendments would solve the mischief that they seek to respond to. That's A, that's B, that's C. We're at C. C is... In addition to fines, other things. Right, in addition, Part C is, in addition to fines, request the offender to repay sums equivalent to the value of gratification, bribe received, or economic loss suffered, which I've just addressed. Court has that sort of discretion. We also have those provisions in criminal justice administration, where if a person has suffered loss as a result of some criminal activity, the court can be asked to make restitution to that person without the person having to initiate separate legal proceedings for recovery.
And then I think the last one, include a requirement and or the duty of any public official or officer, directly or indirectly involved with the procurement process, to declare an interest, to include a conflict of interest, and create an offense where there is non-compliance. So in our jurisdiction, especially as it relates to public officers, well, the issue now is how wide this is. As it relates to parliamentarians, under the Constitution, you have to declare any interest you have in certain companies and so on, and there is a process governed by the Constitution. So I would suggest that any change would have to be made there to the Constitution, but you already have a process where you would declare conflicts of interest. As it relates to public officials, well, civil servants, we are governed by the staff orders. The staff orders sets out provisions relating to conflict of interest, and any breach of that can lead to disciplinary sanction. So it's not that there is no penalty. We just don't usually treat conflict of interest situations as a criminal matter. So we don't usually sanction, create offenses and then have penalties, criminal penalties. And this is what they were asking. But this is not how we usually address conflict of interest in this jurisdiction. Because even with boards and so on, the members of boards, they usually are to declare a conflict. They are not to participate in the decision making, and they could perhaps fall as a public official. So there are other ways that conflicts of interest are addressed, but just not criminally. So we would suggest that that regime continue.
Your recommendation is that this be not accepted, right? Right. Okay. There was one here from the private sector organization. I think it said, we propose that the Act be amended to include a provision which would permit public officials to make an application in writing. That's on page 216? Yes, 2 of 16. Did we have dealt with that one? And what was the decision? Okay, so that was a tick. Yes, that was a tick. Excellent. And we dealt, yes? And we dealt with 7? Right, so now let's look at, and we dealt with, I'm sorry.
I was saying, Chair, I think the error is under the entity that is making the recommendation. I think it was from the PSCs and not the PSOJ. Because when you look at the decision, you see it's saying why the PS made this recommendation. So I think that's the error. So we need to correct that. 1216. Yeah. Yeah. Page 2, yes.
Point taken. So now we move, Member Chuck, to 8. Yes.
Been recommended to amend Section 81A, where appointing the Auditor General be deleted and replaced as Parliament deems appropriate, consistent with the objects and purpose of the Act. The removal of the Auditor General from the Commission does no harm to the integrity of the Commission, as the Auditor General may at any time conduct an audit of the Commissioner's affairs. Furthermore, the Act allows for the Commission to request reports and to enlist the cooperation from all organs of the state. That was deferred.
Right. So we need to make a determination on that. Can we, members, I need to hear from you on this one. Member Guy.
Chair, I don't have a difficulty with the Auditor General being a commissioner of the IC. If the basis is that the AG audits that particular commission, I don't think it is done by the AG. In fact, it is not done by the AG.
Member
I would say I support the Auditor General remaining a member of the Integrity Commission, and in my understanding, where audits are done of the Integrity Commission, they're done not by the Auditor General's department, but by an independent accounting firm, which removes that issue of a conflict of interest. But I would not support her removal from the Integrity Commission.
Yeah, Member Hamilton. And then
Chair, I would support the proposal for the Auditor General to be removed. The reason I believe that a third party is used currently for audits is because the Auditor General is a part of the Commission. So if it is that office is removed from the Commission, then the Auditor General can undertake the necessary audits as it relates to bodies of that nature. The audits that are currently done are not similar to the audits that the Auditor General would normally do.
And
Member Wilmington.
Section 120, 121, and 122 of the Constitution makes it clear of a responsibility and can be a part of any of the board or bodies. So, in effect, this is a breach of the Constitution in including her as a commissioner based on Section 120, 121, and 122 of the Constitution. And this is the basis in which I recommend that, the Auditor General be excluded as a commissioner. Secondly, as Member I said here.
Sorry, member, not to interrupt, but SG? Right, because I think I'll need your opinion on this.
Because based on as Member Hamilton says here, the type of audit done by the Auditor General is completely different from the audit you get from private individual. You need performance audit and all of those, and those external bodies do not go in depth a complete audit and report to Parliament as is required by the Auditor General. And that's section 120, 121, and 122 make it clear.
Member Chuck.
That office should not be, the person holding that office should not be involved or be part of any other body or agency within government.
Very well. Any other member? Member Chuck, I see you, but you're on the phone, so. Okay, so SG.
Maybe I need some clarification. So section 120, section 120, subsection 3 says a person who has held the office of Auditor General shall not be eligible for appointment to any other public office.
No, I'm in
Hold on.
Yeah. No, ma'am, just relax.
So this is in the, this says a person who has held, is not eligible for appointment to any other public office. Also, you have to understand that public office is defined in the Constitution. So public office, as defined in the Constitution, is not the ordinary understanding of public office. So public office means, I will say, office of emolument in the public service. Public service means subject to the provisions of subsections 5 and 6. The service of the Crown in a civil capacity in respect of the government of Jamaica, including service as a member of the Judicial Service Commission, the Public Service Commission, or Public Police Service Commission, and includes public service in respect of the former colony. And subsections 5 and 6 say if it is provided by any law for the time being in office, that an office not being an office constituted by this Constitution shall not be a public office for the purposes of Chapter 5 of this Constitution. This Constitution shall have effect accordingly as if that provision of that law were enacted. And finally, in this Constitution, the public service does not include service in the office of the Governor General, President, Deputy President, Speaker, Deputy Speaker, Minister, Parliamentary Secretary, Leader of the Opposition, Senator, Member of the House of Representatives, Member of the Privy Council, Judge of the Supreme Court, Judge of the Court of Appeal, or Clerk or Deputy Clerk or of either House, or service on the personal staff of the Governor General, or subject to the provisions of Section 79 of this Constitution, service in the Office of Attorney General. So even though 120 sub 3 talks about has held, I would also say that the office of a commissioner is not a public office as defined in the Constitution.
Chairman, I think my reason why the Administrator General, the Auditor General should not be on the committee is that we're dealing with a body that is being provided with almost $2 billion worth of government money. The Integrity Commission is almost as big as many ministries. And it requires, in my view, the full force of the Auditor General's Department to investigate not only the IC, not that I'm saying they have done anything wrong, but it must be clear to Parliament how the funds provided are being used. I'm sure we can find other good persons to become commissioners. It's not the type we have anything against the Auditor General being a member in terms of the integrity of the person. But it seemed to me to ask another public institution to audit the Integrity Commission is so unnecessary when we have a body like the Auditor General's Department that can do it, save and except that we have made it mandatory for her or he to be on the committee, when I'm sure we can find 5 other commissioners to be appointed. So I would strongly urge, I try to reflect, why did we put the Auditor General on it from the beginning? And the only reason I can think of at the time, Chairman, is that the then Auditor General is a part of the Corruption Proceedings Act. You know, he or she was a commissioner from the Corruption Proceedings Act. So it just carried over without us recognizing that the IC would combine the corruption proceeding, the IC, and dealing with a huge amount of government money. The Corruption Proceedings Act was dealing with less than 100 million. Now we're dealing with a body that, you know, to the best of my knowledge, is almost close to $2 billion being spent of government money. And I think the appropriate body to really examine the function of that body is the Auditor General, rather than a private institution doing so. So I would strongly recommend that we remove the Auditor General as a commissioner, because I'm sure we can find 5 other good commissioners.
Chairman, I made it clear probably well over 2 years ago that I am in support of the Auditor General being unfettered from the Integrity Commission, so that she's in a position to audit the Integrity Commission as she does many other government agencies and government bodies. I think we all know that this particular issue has been a controversial one, and that there are those who have criticized myself and others, Member Warmington, for calling for the language being used for the Auditor General's removal from the Integrity Commission as if it is something being proposed to reduce the strength of the Integrity Commission. I want to make it very clear that, in fact, it is the opposite, that the proposal, in my mind, rests on wanting to strengthen the Integrity Commission, wanting to ensure that the Auditor General, who has the statutory duty and authority to be able to audit public bodies, that her role as a part of the commission is what is the thing that reduces the strength of the Integrity Commission. And in fact, were she to be permitted to be the reviewer, the examiner, the check and the balance of that body as well, we may very well not be seeing some of the things in the public domain that have caused many of us concerns in the past. And so I simply want, Chairman, to just indicate my support for this proposal, but also to say that the annual report filed in the Parliament by the Integrity Commission, which is a report that contains the audit report of an independent and private auditor, does not, as Member Warmington alluded to, look at matters like the performance audits. And if you examine the reports, as I have, certainly up to 2 years ago, those reports deal with financial statements and financial matters. The Auditor General's power is far wider than that in relation to her statutory duties. And so it would behoove us, I believe, to ensure that the body that is charged with ensuring the integrity of members of the public service and members of parliament, that body also be held to the standard of audit and review that only the Auditor General, in my view, at this time can provide. May it please you.
It might be useful, Chair. The question was asked of me a while ago of my position, which is supportive of what was said by Member Golding and Member Warmington. But I want to make it clear for those who are listening to us that when the matter of potential conflict, if you call it that, has been raised, even the perception of it is problematic, even if it were not to be seen as real. The perception of it in itself is also problematic, and if we can avoid that, then we ought to do so. And the principle of good governance and even separation requires that those who audit or who provide external oversight over any particular body shouldn't participate in the decision-making within the same body. So I want to support that. Also, something that could be confirmed by council or those who support the committee is that internationally, the best practice when it relates to these kind of anti-corruption bodies is that they don't usually have persons who have financial oversight acting as, like auditors, acting as board members or serving as board members. Instead, external accountability is maintained through reporting and audits and not through direct participation. And those who are supportive of the AG serving have put forward that argument that her direct participation or the direct participation of the Auditor General provides that support. And that argument I think is weak. I think it's actually to the contrary. So as a matter of just providing structural clarity and good governance, I do think that the country will be better served by having the distinction in that role, in not having her being consumed by the potential collective decision, which could also, again, be problematic. I mean, if you want to strengthen the AG's independence, you'd want to avoid any Auditor General being potentially caught or tied to a collective decision, which may, at some later date, have to be scrutinized by the actual AG's office through an audit. So, to me, it's something which we ought best to simply avoid and just ensure that the AG is a fully independent watchdog and keep it separate, in my perspective.
Final point? Yes, just one final point, Chair. I think it is useful to just remind the committee members that Section 36, being the section that requires the Commission to submit an annual report to Parliament, Section 36 requirement, what is supposed to be in that annual report is set out in the second schedule of the Act. And if members recall what the second schedule says, it lists a number of things required in that annual report: description of matters reported to, details of matters investigated, recommendation for changes to law, and a number of things: nature and extent of information submitted to the security forces, description of the Commission's activities during the accounting year, etc. And lastly, it requires audited financial statements. It does not say, so the Act as it's currently drafted does not require the Commission to submit to Parliament any details of how it performs its duties as I understand it and I have read. If I am incorrect in that, I stand to be corrected by the technical team. But this lacuna for me was what convinced me that the Auditor General needed to be unfettered from the Commission, so that in situations where where processes of the Commission are called into question, that her constitutional authority to be able to go in and see that those processes were proper and were executed in a proper way, we need to have that constitutional authority accessible to the Integrity Commission. So I just wanted to further indicate what has led me to my position on this matter. And I do so believe my colleagues as well.
Very well. We have had the full round of discussions on this one with members, and the consensus seemed to be that the recommendation be upheld. So we'll take that one. Well, when the report is done. Okay, next.
To return tomorrow. So I would urge that we stop now. Unless there's anything urgent for us to do between now and 5 o'clock. But I think we could finish by midday tomorrow if we start at 10 o'clock. There's just a few matters remaining, if the matrix.
But no, remember now, we have this matrix of deferrals, and then we have another matrix.
Huh?
Yes.
What?
It's all day tomorrow.
No, but we can finish by 1 o'clock, including everything.
I don't think so. I mean, at the rate that we went, we went today, I don't see us finishing.
Anyway, but can I make sure?
But members, can we agree for half an hour more? Yes? Okay, I hear. I hear. Before. Hold on.
Before you go, just recommit apologies and member looking for apologies.
Yes. Okay.
Confirmation of whether the tomorrow's meeting is hybrid.
Right. Just before on the motion of adjournment. Yes. We just want to recommit apologies and to mention Minister Malahou Fort, who really wanted to join, but couldn't and wanted, in fact, to join virtually, but it was not possible for today. So we look forward to seeing her tomorrow. And tomorrow we begin at 10 o'clock on the dot, and we work through. I gather that there will be some creature comforts arranged. So, yeah. So there will be no excuse. We work through until we have finished the matrix. SG?
Sorry. Yes, that's what I... on the motion of the adjournment, Chair, just asking the members to think about this overnight. So if you're going to be removing the Auditor General, is it that you're just going to have 4 other persons appointed by the GG, or are you going to have 5 persons? Right, so I'm just saying...
No, well, that will come. That's the next one on 8. The one that says appointment of commissioners. Remember? That's the next item.
Okay.
So members have to guide me. Yes, that's the next item. Yeah.
Motion of adjournment.
Food and stuff.
Adjournment.
No.
Adjournment. Of course.
What?
You want to move the motion or just...
No, the motion was moved by Member Chuck. So the motion was moved by Member Chuck and seconded by Member Guy. This meeting is adjourned until tomorrow. at 10 a.m.
Very good. This is going to be our chorus. So when we step, we're going to go, Jesus loves me. This I know. Just like that. Let's try one more time. 5, 6, 7, 8. Yes, Jesus loves me. One more time. Yes, Jesus loves me. Very good. Was that easy or difficult?
Easy!
Difficult?
Easy!
Very good. Let's do it one more time. Ready, set, go.